would you say is the biggest difference in perspective between you as an appellate attorney and the trial attorneys that you work with in trying to relate your advice from the perspective of an appellate attorney? Do you ever encounter resistance from the trial attorney that, oh, I don't think we need to do that, or I don't think the judge is going to go for that argument anyway, so why bother? Do you draw any lessons from your experience in working with trial attorneys in those post-trial proceedings?
Yeah, definitely. And it's a balancing act. We're both trying to do our best to try to represent the client's interests. And so there are times when, let's say in the circumstance when the case is going into trial and I'm involved and I'm providing perspective that I think is going to be really important down the line, at that time, it's the trial lawyers trying their case. And so I will come in, provide my input and advice, but take the back seat. How they try their case is really their call. And I don't want to be second guessing at that time. As things move along, usually the relationship is such that, we're not at odds in terms of what kinds of post-trial motions to file or what kinds of arguments to make. Usually we can talk that through and find a common ground. The one area that I'll say that I see some resistance sometimes is really understanding the standards of review, and even with very, very experienced, accomplished trial lawyers. And probably the biggest one is the substantial evidence standard, and recognizing that if you're going to pursue an appeal, you've really got to accept the facts as found and believed by the trier of fact. Because almost no substantial evidence challenge is going to win. So you've got to be able to tell the story from the perspective, as believed by the trier of fact, not conceding anything, but that's kind of a difficult, thing when the trial lawyer has been living with the case, breathing the case for years and years. So that's difficult. And then really understanding that what a substantial evidence challenge really means, that, let's say in an easy car accident case, the plaintiff is the only person that comes in and testifies on the plaintiff's behalf that the defendant caused a car accident. But then, the defendant came in and testified otherwise, and then 50 people testified on behalf of the defendant. The substantial evidence rule means that the appellate court has to completely 100% disregard everything that was said on the behalf of the defense.
Right.
And look at whether, what the plaintiff said is legally sufficient. And most of the times it is. So that's a tough thing to explain sometimes.
Yeah, that's interesting. You say that's the case even with experienced trial attorneys. And I would imagine it's not a failure to appreciate what the standard of review means or what substantial evidence means, but like you say, they've been living with the case so long, and now with these factual findings, the landscape, kind of the underlying factual landscape has changed. You can no longer assume that, I can just convince the trier of fact of my view of the facts, and then I'm smooth sailing on the law. You have to really pivot after those factual findings have been made.
Absolutely.